is DINI IZZATI PT JUHRI and my matric number is 056841.
My name is FARHANA WAHIDA binti ISMAIL, matric number 056855.
My name is NURKHAIRINI FITRAH binti HUSSAIN and my matric number is 056837.
My name is HUSNA binti ABDUL HALIM. My matric number is 056847. Several computer systems have been developed during the last several decades that can perform tasks that normally require human intelligence, such as writing a computer program, doing mathematics, understanding language, and even driving an automobile. There are also computer systems that can diagnose disease and analyze electronic circuits. Most of the work building this kind of system has taken place in the field called artificial intelligence, AI. Artificial intelligence companies are always looking for new methods to build technologies that will manage difficult tasks in variety of sectors. AI has already made its way into the legal profession in assisting both attorneys and clients. The rising interest in using artificial intelligence in law is gradually changing the profession and closing in on the job of paralegals, legal researchers, and litigators. The use of artificial intelligence in analyzing data and trends for sentencing of specified criminal offences, such as drug possession and sexual assault, has now become commonplace in Malaysian courts. In Malaysia, the first use of AI technology in sentencing took place on February 19, 2020, in the Magistrates Court of Kota Kinabalu, Sabah, in a drug possession case. The counsel for the accused in that case brought up a constitutional challenge. The accused was sentenced to a year in jail, which he appealed to the High Court. E-court function is to manage electronic records in court and is intended to provide significant assistance for effective judicial delivery in Malaysia. In March 2011, Malaysia launched its entire e-court system. There are 4 types of mechanism that form the e-court, which are video conferencing system, case management system, community and advocate portal system, and court recording and transcription system. The Department of Justice in Sarawak and Sabah, Malaysia, has led the way in introducing the e-court system in Peninsula Malaysia. The usage of VCS is important in Sabah and Sarawak since they have the appearance of large land and a lack of transportation. In a normal system, many advocates in Sabah and Sarawak have to spend time travelling to courts that take several days to reach, even though the trial lasts only 30 minutes in certain cases. So the video conferencing system has solved this problem, which not only saves time but also saves money. CMS is a case management system designed primarily to increase service efficiency in managing court cases. Prior to the implementation of the system, the courts handle all the case manually. CMS is commonly used in practice in case management of cases prior to trial as a reference case and the application for a full trial. This technique has sped up the process prior to the trial and saved more time. CAP is a portal system designed to facilitate communication between the courts and the general public. One goal of this approach is to notify lawyers and judges of any changes in trial dates. The system is easy to access and user-friendly. The system of recording evidence in the case was initially invented in September 2004 as a pilot project in 2 selected courts, which are High Court Civil 1 at Wisma Denmark and the High Court Commercial 1 at the Sultan Abdul Samad building. However, the system was introduced by Tun Zaki Tun Azmi, Malaysia's Chief Judge, started in courts across the country in March 2011. This approach eliminates the need for judges or magistrates to write down the details of the trial because electronic devices records the proceeding, also saving time and court processes.
The main issue regarding AI and law in Malaysia is the efficiency in managing cases throughout the year. To be true, the court system in Malaysia frequently criticized for its dilatoriness in resolving disputes, which resulted in backlog of cases piling up. It is normally for it to take about a month or even a year, and it took a lot of work for a case to be reviewed. This happened because law firms spend most of their time conducting research according to the cases they were assigned, which is the groundwork. Apart from the efficiency issue, to achieve greater consistency and accuracy to assist judgment in sentencing also has become one of the issues which leading the application of AI in law. This is because AI machine is based on the self-learning between predictive statistical analysis and machine learning base, which it can keep track of the historical data to find the patterns to predict the future outcomes, observing their environment through data acquisition, interpret the collected structured or unstructured data, able to reasoning or processing the information derived from the data to look for possible solutions depending on its algorithm and decide the best action to take to achieve the given goal. By using the traditional way of making decisions, the accuracy is said to achieve above 65%, while with the assist from AI technology, it can help enhance the precision.
Next, I will explain about legislation approach of AI in Malaysia. Malaysia does not have any particular AI law despite the previous government's announcement will establish a national AI framework. There are some approach for specific regulation on AI which involve the implementation of AI regulation on two levels. The first level is related to the Parliament's promulgation of hard legislation. For example, a special act on AI which includes some fundamental elements which is definition of AI. The second level is referred to the government soft law, which are the perfect platform for dealing with developing AI concerns. Policy hacking and pitching are the most successful ways to create soft laws. Tesla has also included policy hacking into their problem-solving strategy. It is appropriate for policy hacking to be expanded in resolving AI challenges, particularly for AI legislation. Next, I will explain about legislation approach of AI in UK and Singapore. There is no AI-specific law in the UK, but there are some rules that business must follow when creating and using AI or any other technology. The Equality Act 2010 shields people from discrimination in the job and in society as a whole. This safeguard must be considered in the creation of AI and its logic. Next law that related to AI issue is the Human Rights Act 1998, which established the basic rights and freedoms to which all citizens of the United Kingdom are entitled. When adopting technologies such as face recognition, companies and governments must examine how it may influence an individual's right to privacy. Singapore has few laws that control AI-related issues, such as the Patent Act. For an invention to be patentable, it must meet three conditions. First, it must be unique. Next, it must entail an inventive step. And last one, must be capable of industrial application. In the patent application, an AI technique implemented on a computer and directed to solving a problem would likely be deemed an AI innovation. Aside from patent protection for AI solutions, the source code of a computer program may also be copyright protected. The Copyright Act clearly states in Section 7(a)(1)(b) that literary work includes a computer program for the purpose of the Copyright Act.
Now, I will explain about case relating to application of artificial intelligence in court. In February 2020, it stated that Malaysia judiciary was reported that they made a new history where they using AI technology for the first time and passed the sentence in the Kota Kinabalu Magistrate Court. Magistrate Jessica Ombo Kakayun has sentenced two accused who pleaded guilty to 4 cases under Section 12(2) of the Dangerous Drugs Act 1952 after seeing recommendations from the AI systems. So now, I will explain about comparison between legislation of using artificial intelligence in law in Malaysia, United Kingdom, and Singapore. Malaysia still does not have any particular AI law despite previous government has announced that they may be establish a national AI framework. However, AI has been used in Malaysia court for 2 offences in Sabah and Sarawak courts, which are Section 12(2) of the Dangerous Drugs Act 1952 for drugs possession and Section 376 of the Penal Code for rape. Unlike in United Kingdom, currently they still do not have any AI-specific legislation. This is due to their laws, where they have to be technology agnostic in order to ensure that future technology remains subject to an overarching legal framework. And for Singapore country, there are a few laws that control AI-related issue where it can be seen in Section 13 of the Patents Act, and it stated that AI method that implemented on computer and directed to solving a specific problem will be considered as an AI invention in patent application. Although Malaysia only using AI in the court for the first time in Sabah and Sarawak courts, it still has a hoping for a better legal system on tackling this matter so that AI can be used in law for a long time in Malaysia.
To conclude the research, the analysis of application AI and law in Malaysia, in UK and Singapore stated that there is no specific law regarding AI. Various AI applications have already proved to solve many problems in the world. The growth of legal tech innovations in Malaysia is expected to go wider. The adoption of legal AI innovations in their practices will serve to improve productivity and efficiency in working process. AI is also susceptible to exponential changes and technological advancements, especially it operates on machine learning techniques. To sum it up, lawyers and law firms would be best to keep staying up to date on technological development and innovations, whether within and beyond the legal industry, to be better serve the changing and evolving client base and landscape and to remain relevant in the future.